scheduled for a preliminary hearing, Mr. Manley. That is a hearing to determine whether there's probable cause that the offense with which you're charged was committed by you. Do you understand the charge, Mr. Manley?
Yeah.
Okay. Do you understand the purpose of today's hearing is to determine if there's probable cause? Do you understand that also as opposed to your guilt or innocence?
No.
All right. Now let me read the charge to you. The charge says that on or about June the 30th this year, you violated the Ohio Revised Code Section 2923.16283, constituting the charge of discharging a firearm at a prohibited place. The complaint goes on to indicate that you discharged a firearm, in this case a shotgun, on or over a public road or highway, namely Cornell and Allentown roads in Lima, Allen County, Ohio. You've had a chance to go over both the charge and the nature of today's hearing with Mr. Fisher, is that correct?
Yeah.
All right. Are you ready to proceed, Mr. Wally?
Yes, sir.
You have an opening statement?
Your Honor, we had advised the court at this time, Mr. Manley does wish to waive his right.
All right. All right. Let me briefly go over that with Mr. Manley. Mr. Manley, if there's a waiver, that means there'll be no evidence presented for me to determine whether or not there's probable cause. You're simply indicating that you'll agree, in effect, to be bound over to the common police court for a trial if you're indicted by the grand jury. Do you understand that?
Yeah.
All right. All right. That having been said, is the waiver form been signed?
No, Your Honor, I will review that.
I appreciate if you do that right away.
Your Honor, if I could approach, Mr. Manley has executed the waiver for us.
Thank you very much, Mr. Fisher. The court will acknowledge the receipt of the waiver signed by Mr. Manley and his counsel, John Fisher. The court will order you to be bound over to the common police court as suggested and indicate that it would be done for trial pursuant to indictment, Mr. Manley. The question of bond will be now addressed. The bond is currently established at $100,000 cash or surety. Mr. Wally?
Based on the conduct that alleged in this particular complaint, we feel that the bond is appropriate given the circumstances.
The facts of the case, generally speaking, would have revealed what if the evidence was presented?
This individual fired a shotgun, or two shotgun rounds apparently, at the time, right around, looks like, 1:10 in the afternoon at Cornell and Allentown and Cornell. One of those rounds striking a habitation. He was shooting actually would indicate had a vehicle with some other people in it. We feel that the bond, as presently said, is appropriate given those circumstances.
So we may be looking at questions of felonious assault, such things as that also on top of the charge that I'm now looking at, depending on what the grand jury does. Is that right?
Your Honor, yes. It would be, I just looked at the code section and maybe other violations, including possibly discharging a firearm into a habitation would be a felony in the second degree. But we'll present all those to the grand jury.
Very good. Bond, as stated, Mr. Fisher, is $100,000 with cash or surety. Your position on this?
Judge, I just would indicate to the court that Ricky did turn himself in when he found out there was a warrant on this case. He's lived in Lima all of his life, lives on West Spring Street, 1057, with his aunt. He has little or no record, no juvenile record. Like I said, he turned himself in immediately when he found out there were warrants in this case. Can't speak much to the facts of the case, Your Honor, but as far as his willingness to appear at future court hearings, obviously the fact that he turned himself in speaks volumes to that. So would ask the court to take that into consideration in setting the bond.
All right. Well, this court, the significant way when firearms are involved in discharge, particularly when we're dealing with a situation where there was a car full of people, a house that was struck, and the discharge of a weapon with 2 rounds across the roadway is suggested. Court field bond will be continued at $100,000 cash assured in this situation, a serious case. Anything further?
No, sir, I would just indicate, I just advise that it wasn't 2 rounds, it was 1 round. 1 round was racked out of the gun and fell onto the ground, so there was only 1 shot fired.
Nothing further.